All right, everybody. Today we are going to talk about the trademark process, and it is a long one from the outset. So don't think that you're going to file a trademark application in a week. You're going to have a federal trademark registration. It does take some time. So let's just kind of get into it and get into the process of how the USPTO works, which is the United States Patent and Trademark Office, what you need to do on your end, and then how we will help you file and get that trademark registration that you want. So to begin with, you have to choose a trademark. So for instance, whether you're selling a product under a trademark or a service or it's your company name or whatever it is, pick your trademark. It could be a logo, it could just be plain words, it could be a phrase. It doesn't necessarily matter what the trademark is. So you send that to us, and then after that, you got to let us know, what do you use this trademark in connection with? Are you selling sporting goods? Are you selling liquors? Are you selling a service, like a financial service, like an accountant firm or something, or legal services like us? Let us know what you do under the trademark. List it out as detailed as possible. The more things you put, the better. We don't have to get into the details of that, but the more goods or services that you have listed, the broader protection you will get, which is helpful, and that's ultimately why you're filing for the trademark in the first place. So when we get all that information, we get your trademark and we get all the goods and services, we are going to do what's called a USPTO knockout search. And that is, we look at the USPTO database for all the trademarks in the country that have been filed, registered, abandoned, whatever, they keep them all. And then we will see, is your name close to somebody else's name? Because if it's too close, the USPTO will deny your trademark application. So we just want to make sure that we're not going to file something and waste your time and money if it's not going to be registered. So that's what we do with the USPTO knockout search. After that, we'll do a comprehensive common law search. And what that means is, say for instance, you're selling tennis rackets in Texas, and you're getting a little big, and for some random reason, there's a person in upstate Michigan selling tennis rackets with the same exact name. We'll find that out, and we'll let you know what potential issues that could cause down the road and how to approach it from a USPTO trademark application standpoint and things like that. Lastly, when we give you our search results back, we will also let you know how distinctive your trademark is. So distinctiveness is just, for instance, you can't call a water company water and get trademark application and registration for it, because you can't hijack the name water, because that's actually what it is. But on the flip side, if you make up a word like Google, and you just make up a word and it's not really related to what you're doing, that's pretty cool, and you have a very distinctive trademark. So we'll let you know from that perspective whether or not your trademark can be registered. After we do all that stuff, we will get some more information from you after sending you the letter. So for instance, we might need your address, the name of the trademark owner, the first time you used their trademark, and things like that. Now, in this video, we're not going to get too into it, but there's two ways you can file a trademark, one in use and one intent to use. We're going to make a separate video and blog post for that, so stay tuned for that. But before we file, or at some point, we will need a specimen. A specimen is just something that shows you using the mark in commerce. So why does the USPTO require a specimen? Well, it's just so that way you can't take a trademark and just claim it as your own if you're not even using it. So the specimen just shows the trademark in use. It's a little technical, what counts as specimen and what doesn't. Again, we have another blog post and another video specifically about specimens, so if you're curious, check that out. So then, based on the information we receive, the specimen and all that, we will prepare and file your trademark application. But before we officially confirm the filing, we will send it to you for your signature, so that way you get one last look. You get to peek and poke at everything, make sure we spelled everything right, and we have the right address, the right owners, the right phone numbers, the right goods, the trademark is exactly spelled right, and all that for you. And then after we file the trademark, it takes about 3 months, sometimes longer. The USPTO might back up, but an examining attorney will look at it. And yes, an attorney does work for the USPTO to check all these applications. Not one attorney, there's a lot of them, obviously. So then the attorney will come back to us, and one of two things will happen. Either he'll approve a publication, which is sweet, golden, or he will send an office action. An office action could be for anything, but there's some kind of defect with the application, such as, I don't know, maybe they tried to call the phone number and it didn't work, or the email is not like .com and for some reason it's a .net. Those are pretty easy to fix. Those take no time. Sometimes the examining attorney will see a different trademark that's kind of similar, but they want you to explain how are you different, why should I approve this if this one's already on the register. If that happens, we will handle that office action for you, and we will try to overcome any of those obstacles. Some office actions are no concern, some are bigger concern than others. Ideally, we do a lot of the work before the USPTO knockout search, the comprehensive common law search, and all this other stuff in preparation of filing your trademark, so that way we can avoid these issues altogether. So yeah, hopefully it would just go right to publication. Now, what happens at publication is that for 30 days, anybody in the country or the world really can file an opposition against your trademark for some reason. Say somebody was using the trademark in Alaska and we didn't catch it, but we would have caught it, let's be honest. But say they just did, and they were like, no, that's my trademark, I've been using that for 37 years, and I'm a mom and pop store, and blah, 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 and I can't believe this is going to be registered. They could file an opposition, but the likelihood of that happening is low, because we do our due diligence beforehand, specifically to avoid that kind of situation, which can create a mess and a headache for you. Then after the 30-day publication period, in about 12 weeks, 3 months, 12 weeks or 3 months, I guess it's the same thing, you will get a nice certificate, federal registration from the United States Patent and Trademark Office, and then you will have that, and that baby will be nice. So yeah, let us know if you have any questions or concerns about the process or how we do it. Thanks.